This video contains excerpts from an online workshop that the U.S. Asia Law Institute held in June 2020. The workshop participants were legal professionals or scholars from mainland China, Taiwan, and Japan, who were already broadly familiar with the United States criminal procedure and evidence rules. The presenters were experienced judges, defense counsel, former prosecutors, and law professors. The workshops were designed and led by U.S. Asia Law Institute Senior Research Scholar Ira Belkin, a former federal prosecutor.
This session is about digital and machine-generated evidence, a topic that is really cutting edge, both in terms of the law in the United States and around the world, but also cutting edge in terms of technology. And we arranged this session in response to so many questions that we received from our colleagues in Asia about how the United States is dealing with new technologies and evidence created by new technologies.
We are both part of a national organization that is run by the National Institute of Standards and Technology in Washington, D.C. That is the only organization left in the United States now that is trying to have some sort of coordinated response to the issues going on in forensic science, from digital evidence to DNA to toxicology to fingerprint analysis. We're talking about information that is stored on devices such as computers, mobile phones, and the analysis and interpretation thereof, and all of the issues that are related to that. But digital evidence is one subset of what we might think of as machine-generated evidence and also electronically stored evidence. Some evidence is actually generated by machines. There's an algorithm that creates an answer or a number or some data that's used in a criminal trial to prove guilt or suggest innocence. And then there's electronically stored information like an email that a person has written, or a social media post that a person has written, but it's on a computer. So we'll be dealing with issues of authentication, but also reliability and confrontation and everything in between.
When practitioners start a case, often what we start with is the discovery, which we'll talk about in a moment. As a criminal defense attorney, usually that information comes from a prosecutor. When I first started practicing law 15 years ago or so, that usually meant paper. For us, a big case was a banker's box. 500 or so pages of discovery would have been a big case. But now in almost every case I have, it begins with the prosecutor asking me to give them a 1 terabyte hard drive. And this is a hard drive that is usually filled with data and discovery. But if we were to think about how much 1 terabyte is, if we were to look at music, for instance, how many songs fit on a 1 terabyte drive? 200,000. What about pictures? How many pictures could you fit on there? 2 million. What about emails? Over 100 million. And what about text documents? The answer is over 600 million. These are very, very large numbers when we're thinking about data. This is far more information than we ever received 15 or 20 years ago when we were trying cases. There's a lot of reasons for this. One of the biggest ones is cell phones. Nowadays, everyone has a cell phone in their pocket, which a lot of times we think of as being a computer. And they are very similar to computers in that they generate a lot of data. But this also means that data often lives in more than one place. And we could think that how many places do your emails live? Do you have emails on your phone, on your computer, maybe a tablet, and backed up to the cloud. So data lives so many places these days, it's becoming very difficult for us to figure out where do we begin even starting with a case. But what about a case where you have 1,000 emails or 10,000 emails, or cases I have right now with over 100,000 emails? The answer is you're not going to read all of them. And so you'll have to come up with search techniques to figure out which ones to, how you're going to find them. But I also want to make a distinguish something here. What we're talking right now is about what we call discovery in the government. And that is information provided from the government to defense counsel. Not all of this is going to become evidence at trial. In a case with terabytes worth of data, sometimes by the time we get to trial, there might be only 10 or 15 pages that are really at issue.
The first issue that we're going to talk about in terms of this data that exists in the world becoming evidence in an actual case is authentication. And authentication, as a term that's used in United States evidence law, simply means that the proponent of evidence, the person who is trying to introduce the evidence in a case, has to prove that the thing, whether it's testimony or a document or an object, is what the proponent claims it is. So if I'm trying to say that this is an email that John Ellis sent on April 6th, that's what needs to be authenticated, that John Ellis authored this email on April 6th, and that this thing that I want the jury or the judge to see is actually that. How do you go about authenticating something? It's a low bar for how much proof you have to offer for whether something is actually, the web page you're claiming it is. But you do have to offer some proof. Sometimes the way that you do that is through the testimony of a witness, or to bring in somebody, a records custodian, or somebody who actually knows something about how records are kept, and you actually put them on the witness stand. That is expensive, to bring in live witnesses to have to authenticate something. And so in the United States, we actually have a list of documents that are called self-authenticating. And before 2017, that list really only included things like, sealed birth certificates, other public records that we take as presumptively what they claim to be. But when it came to machine-generated or electronically stored information, litigants really had to spend a lot of money trying to authenticate this type of digital evidence. And so in 2017, there were two different categories that were added to the list of self-authenticating documents.
So this is Zia Vandenborn. She is an artist from Amsterdam, and she told all of her thousands of followers on Facebook that she was going on a 2-month trip to East Asia. And as she was there, she began posting pictures of her adventure. There was a picture of her snorkeling, a picture of her walking on the beach, and then a picture of her standing in the water throwing up the peace sign. She spread these photographs and these stories out over approximately a 2-month period. And at the end of it, she told everyone the truth. It wasn't real. She had simply taken photographs of herself, and she photoshopped herself into all of the pictures that she had taken. So as you go through, you can see that she even included the shadow, an empty beach where she put herself, and then finally, she put herself underwater. This happened 6 years ago, and by today's technology, this is a fairly crude way to add items to a photograph. This was done by hand. It took a lot of time. There are sometimes ways from a forensic standpoint that we can go back and determine whether or not these are actually fake. But the technology has gotten so much better over the last few years. Study these 3 people and tell me which one of them is not real. Well, here's what I want to tell you. Not one of these people is real. All of these photographs were generated using AI. There is a computer system out there that was created that tries to determine what people look like based on photographs it's seen in the past. This is very scary for a lot of reasons, because how would one go and determine whether or not this is a real photograph or not? The interesting answer is that we use AI to fight AI. The technical term for this in the United States is called a deep fake. And a deep fake means an image or video or audio that appears to be something that it is not. How are we going to be able to educate the court, opposing counsel, and jurors about whether or not an item is what the person says it is? The term that judges use in the United States is objections to authenticity go to weight, not admissibility. Meaning, yeah, you think that's not a real picture, that's fine. The jury can see it, and then they can determine what, if any, weight or if they should care about it at all. And that can't be the right standard with digital evidence moving forward, because most of you believed that at least one of these people was a real person. How does it feel to know that none of them are real? This is by a website called thispersondoesnotexist.com. It's for this reason that when we talk about authentication, it is important and it has to mean something to us.
Even though machine-generated and electronically stored information can now be authenticated without live testimony, you still need some sort of certification by some qualified person, somebody who understands the program, somebody who has inputted the data into the algorithm, to explain that the process produces an accurate result, but you're still relying on that qualified person. And the comments to this new rule make clear authentication is only the first step, and you can still dispute at trial whether something is what it claims to be. But the fact finder will see it, and if the fact finder believes it, then those credibility determinations are pretty much off limits on appeal and are pretty final. Again, 13 relates to records that are generated by machines. And so imagine a timestamp on a photograph, a Windows registry on a computer that lists the point at which certain drives, like a USB drive, are taken out of the computer, such metadata related to text messages and when they were sent. That type of metadata is created by a machine, not a person. 902.14 deals with evidence that is copied from a device, electronically stored information. So imagine text messages where what you're really trying to say is, this is the text that John sent me. Maybe the timestamp was machine generated, but the text itself was written by John. And so you can show that through circumstantial evidence as well. You know, I was in an exchange with John at the time. I know the sort of words that he uses in the texts and emails that he sends me, that sort of thing. A forensic copy of phone contents. You'd have to have a qualified witness to give a certification, not through live testimony, but at least a certification that says this is a true copy of what I found on the suspect's phone.
if in discovery you provided a photograph to me, one of the things we would take is a hash value, and I'll explain that in a moment. If I was to alter any part of the photograph, let's say I was to Photoshop out something or Photoshop something in, it'll change the nature of the hash value of that photograph, and so we'll know that there's a change. 902.14 really gets to the file level and a folder level. So if I was to provide Andrea right now an entire folder or hard drive with discovery on it, I could take a hash value of it, and then later if she claimed that I gave her something or did not give her something, then we could go back and do an additional hash analysis and figure out if that was accurate. So let me just walk through how this happens or how this works. So if we started with something simple like John, if I put the word John through a hash function, it's going to give me a hash value. So a hash function is just a mathematical formula. It's really, in this case, because this is digital, it's looking at all the digital part of John, the ones and zeros at the byte level, and is then calculating a unique number for that. So you can see John has one value, but if we do John won a big trial, then the hash value is completely different than John. But look what happens in the third example. Just changing a capital J to a lowercase j completely changes the hash value to be completely different. Now, theoretically, no two digital items could have the same hash value. I say theoretically because there have been a lot of experiments to try to prove if you could have two documents that were different that had the same hash value. Generally, in the real world, we cannot make that happen. But there is a way that has been proved in a laboratory, and it's called cache crashing, where you could have two separate photographs, for instance, that had the same hash value. That is so theoretical that hash values are now used as to prove evidentiary integrity. So I can prove that the picture that I gave to Andrea is the same as the picture that we're introducing into evidence at trial. Same thing with large data sets. This is often used to make that determination. This is also used in big data cases where you can go through, and if we're trying to figure out if we received the same file on more than one occasion, we do a hash analysis and then compare the hash values so we don't have to look at every page within a large discovery set. So this is something that has both a forensic significance, but also a discovery and evidence significance as well. And the great thing about hash values is it's looking at, for instance, if we're looking at a document, what it's looking at is the content of the letter. So here if we have, "Dear Judge, I confess, forgive me, John." Well, if I was to name this confession as the document, then it's going to have a hash value. But if I name it denial, it'll still have the same hash value. So I named it confession, one hash value. I name it denial, it has the same one. Because when we're doing the hash analysis, it doesn't care about the title, it only cares about the contents. And that's true for other metadata associated with this also. And metadata is obviously just data about data. An example would be the date it was created, the date it was modified, the date it was last printed, etc. When we're doing a hash analysis, the program doesn't care anything about that. It's only looking for the contents. And so that is an example of an algorithm, but one that is really well accepted within the community.
John, I actually have a question. So does that mean that there's really no way currently for somebody to tinker with the hash value to make it seem as if they know that this hash value is associated with a file they shouldn't have, like an image of a child, a sexual image of a child, they can't tinker with it after the fact to try to scrub it somehow from their computer?
Yeah, that's one of the areas that's used most commonly in the United States. It's in exploitation cases, and the government has a list of known photographs that are contraband or illegal, and they have all of the hash values for those. and they routinely go through websites to look to see if that hash value of that image exists in an email, on a website, or in a text message. And when they find that there is a hash match, then they generally are confident that that means that the image they're going to look at is the contraband image. There are theoretical limitations to this, but generally speaking, it's good. There are different types of hash values. This is a simple one. This is a 32-bit. Most of the ones we're dealing with now are a minimum of 256. Wow. And so that's SHA-256 or secure hash value. So there are a lot of different types out there. For instance, when you're banking, most banks have a minimum of using SHA-256, but that continues to increase. So the more complex the number is, that gives us more certainty that there is a match. But there are different levels of hash. This is just a simple one.
How does this play out in practice?
902.14 was really necessary. And where it came about is, if we're getting ready and we're in the discovery process and you have a Word document, and I would say, I want the Word document, and you would say, you would say, no, I'm going to give it to you as a PDF because I don't want you to be able to make changes. And I would say, you can trust me, I'm not going to make changes, but look, I really need this because I want to figure out more things like, when did you start writing it? When did you last print it? Were you using track changes? I want to be able to see the original document. And so for far too long, the reason opposing counsel would have refused to give the native file format was, well, you could make changes. So what's great about 902.14 is you can say, look, we'll hash it. If you made any changes, we'll figure it out. So that, I think, was a good reason. My concern about 902.13 is this. I think, one, it's meant to save money. And I think it's great in a civil case because, experts are expensive. And if you're going to have to pay someone hundreds of dollars an hour to, come to court and to testify, that is very expensive. And one of the ideas between 902.13 is you could just have an expert write essentially a declaration, prove that they were certified, and then they would enter that instead of live testimony. I think in practice it's really difficult and wrong, but I would say just even from a more practical standpoint, there's a lot of dispute about what some of the terms mean in 902.13. It's going to take a while for those to play out in court. I think that means, though, the flip side is that criminal defendants, could introduce that evidence because we don't have the same restrictions. But we will be talking more about the Sixth Amendment a little bit later on.
Even the advisory committee notes to those two rules make clear that the proponent of that sort of digital evidence still has to prove that it meets the other requirements for admissibility, not just the Sixth Amendment, that it wouldn't violate the right of confrontation that John mentioned, but also that it is relevant, that it tends to prove something that matters in the case, that it is not hearsay, which is a rule of evidence that it has similar purposes to the confrontation rule, but is applicable in both civil and criminal cases and applies to the criminal defendant as well.
It's not uncommon now for us to have a case with hundreds of digital devices. I have a case right now where the government in one search warrant seized over 150 digital devices and included everything from computers to iPads to cell phones to thumb drives. It is a lot of data. And again, a lot of it was duplicative. But even in our standard case, where does data live? If you have a phone, then you probably also, or you might have a computer, you might have an iPad, and those sources could be duplicated on there. But what about the cloud? So often that we can get data on the cloud and we don't even have to have the device itself.
Yeah, so one issue that comes up when you are seeking information from an online platform, you want to ask Facebook, Google for a number of emails that were sent from one person to another, or you want Facebook to give you information about social media posts from a alleged victim in a case, let's say. Another example recently with respect to something called spoof card, a defendant in a recent case essentially was able to prove his innocence. He allegedly, according to, I think it was an ex-girlfriend, who had accused him of sending her threatening text messages and such. And he denied it, and he was able to get data from the company spoof card to show that she actually sent the messages to herself, and that she used this application to basically disguise which number it was coming from so that it would not look like she was the one who had sent them. But the only reason that that defendant was able to prove his innocence in that way and get the case dismissed was that spoof card was willing to turn over that data. When it comes to discovery in a case, that relates to getting information from the government. You just need to ask the government for it. And if they don't give it to you, you can ask a judge to enforce that. And the federal rule of criminal procedure that governs discovery of this sort of thing is Rule 16. And basically every state in the US has some sort of analog to Rule 16 that looks similar. So for example, you have the right to seek reports of examinations and tests that are in the possession of the government, that are either material to the defense or that the government intends to introduce at trial. Also, with respect to expert witnesses, if the government plans to call a digital expert to the stand, you have a right to information. In a criminal case, believe it or not, you don't have a right to as much information as you do in a civil case. And I think John has been working on some discovery reform along those lines. And so there's an actual amendment to 16, but you have a right to a summary of the expert's testimony, the expert's qualifications. But in terms of the limitations of Rule 16, it's not a constitutional requirement. This is basically a law, a statute that it's a court rule. It's reciprocal, which means that the government can also ask for this information from the defense, get a summary of a defense witness's, expert witness's testimony. And what if it's not in the possession of the government? So you can't use Rule 16 to get information from Facebook or Google or Snapchat. So what do? You may have to seek a court order called a subpoena. And there are a few problems with respect to defendants subpoenaing information from these companies. And I should say that when the government wants information from Facebook, they've got a couple of options in front of them. They can seek a warrant, which is an order from a judge that is signed based on an affidavit that the police submit. They have to show probable cause that some evidence relevant to a crime is going to be found where they're going to search. And if they get a warrant, Facebook basically has to comply. But they also can just seek a subpoena. They can just subpoena the records without even getting a warrant. There is, in order to subpoena something, it generally just has to be material. It has to be relevant to the preparation of the case at trial and the issues in the case. But when it comes to electronic data and electronic communications, there are privacy statutes that limit the ability, especially of the defense, from getting this sort of information from Facebook and Google. So let me just give you an example. So the Electronic Communications Privacy Act, I think, which was passed in 1986, essentially, there's a bunch of digital evidence in a case, but how does it actually come to you? If you're a criminal defense attorney or a judge or a prosecutor, it typically comes to you in the form of a report from a digital forensic expert or software.
So when we think about forensic evidence, I want to move from, we talk about you get a phone or you get a computer, what happens next? What generally happens in criminal and civil courts in the United States is someone will take the device and they will use a forensic process, which I'll explain, to get information off of the device. So when we use the term forensic, we're really meaning using the term in a scientific way, that someone is going to get information off of the device and do so in a way that won't harm it. That's one of the concerns we always have, especially with digital, is if you were to take your phone and turn it on and look at a couple of things and turn it off, that would change the characteristic of your phone. So if I later got your phone and took all the data off of it, things would be different. And so we always want to make sure that we do things in a forensically sound way. With digital forensics, what that generally means is it's going to go through this process where first data is extracted from the device, and then there is an analytical part of it where there is analysis done. And then from there, we have to convert that in a way that people who don't have the $10,000 software can interact with it. And that's where reports come in. Reports are great, but they can be problematic. And I just want to give you a couple of examples right now. If I was to come into your house right now and you were nice enough or naive enough to let me copy everything off of your computer, if I copied everything that you had off your computer, I would never be able to reduce all of that to a report. What would you do with an executable file or with a program file? Those don't really reduce to paper or to other types of reports. So not everything is going to be there. When it comes to mobile devices, though, like cell phones, we know that we don't get everything off of the phone when we extract data from it. And so there are limitations. The first thing is I'm not going to be able to get all the data off of your phone. And secondly, not all the data on your phones can be reduced to a report or a writing. So it's one, knowing that there are limitations. And the second thing is knowing that there are certain limitations built into the system itself. There are different ways, different techniques or methods or tools I could use to get some of the data, a lot of the data, or most of the data. And so it's just knowing that when you look at these reports, never assume that this report contains everything that was on the device. Secondly, the report itself is only as good as the person who was using the tools, which we're going to talk about more in a moment. And sort of the third thing is that just because you have this report, the main thing is there could be more data out there. This might come up in a situation including where you see a text message. If you don't see other text messages, does that mean they weren't there? And a lot of times we begin with the assumption that just because we don't see it doesn't mean it didn't exist. So there's a lot of questioning that has to go into these reports. Don't fall into the trap of thinking that reports are perfect.
In the United States, a judge will determine whether to allow a digital forensic expert to testify to an opinion about their expert opinion about what was on this phone and when. Did this person have knowledge of this file based on what they found on the phone? Is this everything that was on the phone at the time? And how we determine whether that expert method is reliable through validation, et cetera.
When it comes to verification and validation, when we talk about the forensics, this is really the sort of bedrock and where forensics begins. Verification and validation are important. So in simple terms, validation means that a tool works the way it's supposed to. and verification means the tool worked the way it was supposed to on an occasion. We're going to talk in a minute about a hammer and a nail. So if you wanted to validate a hammer, you would say, okay, what's the purpose of the tool? The purpose of the tool is to take a nail and drive it through wood. So you build a tool, and your tool is a hammer. And you go out there and you practice and you say, yeah, every time I hit the nail the right way being key, it's driven through the wood. So that would be validation your tool works. Verification is going back and make sure your tool worked right on an occasion. And you would often do that with other tools or with other people. So verification and validation, bedrock principles. And this is the first time I'm going to tell you why I think live testimony is important. I had a case one time where there was a federal agent who was working with a prosecutor. And if you were to look at the gentleman's resume, it was very impressive. Again, he worked for a national law enforcement group. He had a master's degree in forensic science, and he had been practicing for 5 years. My second question on cross-examination, and again, this is the chance where I get to confront and take a look at the government's expert. I said, sir, I want to talk to you about verification and validation. He said, that's great. I said, sir, you're familiar with these terms? And he said, I've never heard them before. Now, this is not the answer that I was expecting. This just proved that, and it turned out that this gentleman couldn't support the opinion he wanted to give in court. But without live testimony, we would have never figured that out. And so that's just one of the plugs I wanted to have for live testimony and why it's hard to rely sometimes simply on a resume.
In other words, without a live witness, you would just have a paper report that would come in and everyone would assume that's reliable evidence. But having the person who created that report in court, you were able to show he didn't really know what he was talking about, and the conclusions in his report were not reliable.
There's a question about live witness testimony at trial. You could imagine possibly doing a deposition of an expert like that and getting some interesting responses. But in criminal cases, it's really the norm that you don't have any chance to depose witnesses unless somebody is, very ill or something. And COVID-19 may change some of those norms, but basically in criminal trials, this is your only chance is real-time questioning, either in a motions hearing right before trial or at trial itself. I just wanted to mention the 3 cases that in which the Supreme Court has laid out the requirements for admission of expert testimony in terms of reliability, and then show you how these cases have been now codified in what is now Federal Rule of Evidence 702. And even though that's only binding in the federal courts, it's been very influential, and most states have adopted the Daubert standard. So in 1993, the Supreme Court interpreted the Federal Rule 702, which relates to admissibility of expert testimony, as requiring a showing of evidentiary reliability, which they said was the same thing with respect to a scientific expert. It basically means showing that the expert's method is scientifically valid. Sometimes in the literature that's called foundationally valid. Is the method valid? Before we even get to how the analyst is. In General Electric versus Joyner, 4 years later, the Supreme Court said, by the way, this reliability requirement not only relates to the method itself, but also the way in which the method was applied and the conclusions that were actually drawn by the witness in this case. And if the witness unreasonably applies a method, then that is something that could actually be a barrier to admission. So it's not just that it looks bad for the expert. The expert may not be able to testify at trial. The jury will never hear this evidence if a judge determines by a preponderance of the evidence, more likely than not, that the method is reliable. And then Kumho Tire in 1999 said that this reliability requirement applies not only to scientific testimony, but all expert testimony. Why did they feel the need to do that? Because some experts don't think of what they do as, quote, science. It may be a technical area. In our forensic fields, you have actual forensic experts with respect to, say, firearms comparison, who actually say that what they do is an art, not a science. And it used to be their way of trying to get around evidentiary requirements for scientific testimony. And the Supreme Court says, no, either way, you got to show that the method is reliable. And so now Federal Rule 702 has basically codified all three of those cases by saying the expert has to be qualified, the expert has to actually say something that helps the trier of fact. It can't be something that the jury can figure out on their own. The testimony has to be based on sufficient facts or data. The testimony has to be based on a method that is reliable, and that method has to be reliably applied in the case at hand. And so this really gets to the method versus the analyst.
If we were to take this out of the courtroom for a second, if you were going to buy a new home, and the carpenter who was putting together the frame of the home, you would want to make sure that he or she was following the same procedures that other carpenters were. And you would want to do that because carpenters have been doing this for a long time. You would want to make sure that they were using the right materials and that they were using the right materials in the proper way. That's really what we want when it comes to forensics in the courtroom also. So we talked about the tool. So the tool in this case is a hammer. The method would be an overhead swing. And then the second part would be hitting a nail. But why this picture turned out to be great, does anyone notice what's wrong with this picture? I'll tell you, that's a screw. Do you use a hammer on a screw? No. So this would be an example of using the wrong tool based on what you were trying to accomplish. And it's interesting because screws look a lot like a nail and they have the same function. It's really to go through wood to bind more than one thing together. But there are different techniques and different tools you would use to do that. So this turned out to be a perfect example of when this can go awry. One way that you can validate a tool is you can have someone else do it for you. So commonly there are groups out there that will say, I use this digital forensic tool. I followed the directions and then I looked at the results and the results were valid, meaning they are what I thought they would be. That's great. That's an example of validating a tool. I had a case recently where an agent used a brand new tool and it had not been validated. And the agent had a separate thing he could have done. He could have done a validation himself. There are tests out there that are publicly available and you can use data and you can make sure the tool works the way it's supposed to work. This guy did neither. He couldn't prove that the tool worked the way he said it would work. What he said was, yeah, I used this tool a bunch and every time it worked. And I was like, but how do you know it worked if you never compared it to other tools? And he was like, but it's really pretty. Like the output and the report was really nice and it was expensive and he really liked it. And I was like, yeah, that's not validation. And the judge agreed. The judge ultimately found in a Daubert hearing that the person could not testify in a trial because the tool they were using had not been validated. And the reason that the court found that is because when we're dealing with Daubert cases, really what the court wants to know is this reliable? And for us, validation and verification help get to reliability. And so if we don't know the tool you're using works the way it's supposed to, and we don't know if you used it right on the time that you used it, then how can you say it's reliable? And so that's really where this comes in. And hopefully this example helps make sense.
Just wanted to mention one of the reports that's most recent about forensic evidence. The report is mostly about pattern evidence and not necessarily digital evidence. It gives you sort of a template from thinking about these different layers of validation. And also the fact that whether we're talking about a human analyst who is just looking at two bite marks and trying to figure out if they came from the same person, or if we're talking about digital software or some complex DNA software, we're still talking about the same concept of, is this method foundationally valid? And did this analyst apply the method correctly? And so when we talk about a machine being a black box, or there be something, something wrong with software output, we could still use that same terminology when it comes to human analysts. So I just wanted to show a couple of things that will put this conversation about digital and machine evidence into perspective. So this report to the president from the President's Council of Advisors on Science and Technology, PCAST, called the PCAST report, came out in 2016, and is really the most recent pronouncement from a nationwide body of scientists about the foundational validity of various types of forensic pattern evidence, like latent fingerprint analysis, like firearms comparison, like DNA. And it talks about black box testing and the need for testing of a method to determine how many times it gets it wrong, how many false negatives, how many false positives, and to develop an actual error rate. And you'd want to know the error rate of software as well. So you could do black box studies with respect to software that's used to analyze pretty much anything, including DNA. I wanted to give an example of a high-profile error that made the headlines in the United States that I think shows you both the problems with a method and the problems with an analyst, and also the sort of intersection between humans and machines. So in the United States, when, let's say, the FBI, the Federal Bureau of Investigation, is trying to sees a fingerprint at a crime scene and is a latent fingerprint and tries to figure out whose prints it might be, they take the print off of the surface where they find it, and they can run it through this huge database they have of millions of people's reference prints. And this automated system spits out, let's say, the top 10 matches. And so there was a case, the Madrid train bombings in 2004, the terrorist attacks. They didn't have a suspect, but they found latent prints on a bag, I think it was a bag of explosives, that they thought belonged to the perpetrator. The FBI put that print through the automated system. It came back with the top matches. The FBI analysts, who are generally the top of their field, looked at these and determined that there was an absolute match to this person, Brandon Mayfield, who was the lawyer in the United States, in the state of Oregon. And they said, we got our guy. He's the Madrid train bomber. And the Spanish police said, are you sure about that? And so the FBI looked, and they said, well, look, he's a terrorist, I guess. And he hasn't left the country in a long time, and they found that to be suspicious. So he was still their suspect until the Spanish authorities found someone else who matched even better, and they determined that that person was actually the perpetrator. And so Brandon Mayfield, the FBI acknowledged, was falsely accused of being the bomber based on this mismatch, which they were absolutely sure was a match. There was a big Inspector General report about this case, but the thing I wanted to highlight was one concern that the Inspector General had about something that we might call automation complacency, the idea that a machine spit out these top 10 matches, and the human who was looking at these matches assumed that the perpetrator of the bombings surely had to be one of the 10 matches. And so they just picked the one that was the best match, and it was Mayfield. But really, they should have considered the possibility that the real match wasn't in the database at all, which turned out to be the case. So let's assume that you lose your reliability challenge under Daubert if you're a defense attorney, and this digital evidence or this DNA evidence or whatever it is coming in at trial. That doesn't mean that you've lost the case or lost the ability to contest the accuracy of the evidence. It's just that now you have to do it through confronting the evidence at trial. Now, in the United States, the right of confrontation is a constitutional right in the Sixth Amendment. In all prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. Generally, that has been interpreted as meaning you have the right to cross-examination at trial. You have the right to physical confrontation, looking the person in the eye, and the right to place them under oath. And so the only way that you can get those things is through live testimony of the witness. This same concept, this preference that the Anglo-American system has for live testimony is also, you can also see it in the rule against hearsay. This is not a constitutional rule, this is a rule of evidence. Every jurisdiction has it. I think the United Kingdom has gotten rid of the hearsay rule in civil cases. We're basically the only system in the world that still loves the hearsay rule. Has to be brought in through live testimony. You can't bring it in through an affidavit or a certified statement or a rumor. And that applies to expert testimony as well. Essentially, in either a civil or a criminal case, we start with the presumption that a person's assertion about anything, if it's being brought in to prove the truth of that assertion, has to be brought in through live testimony. You can't bring it in through an affidavit or a certified statement or a rumor. And that applies to expert testimony as well. By the way, I hope it's very clear that when I was talking about Brennan Mayfield, I was suggesting with respect to his religion and the fact that he hadn't left the country, I was suggesting that the authorities were infected with confirmation bias in assuming that those details were anything other than completely innocuous. Okay, so this is great for a human digital expert like John was cross-examining at that great hearing. You can put them on the witness stand and cross-examine them. But with respect to a machine, you can't cross-examine most machines. You can't physically confront them or put them under oath. Machines can certainly be deceptive, but we don't think of them as being having souls or wanting to be insincere. So what does confrontation mean when it comes to machine evidence? And it's a very difficult issue that the US hasn't really figured out yet. But let's just think of it in the same way that we thought of those black box studies. Yeah, you can't physically confront a machine, but you can get inside of it and try to think about what could go wrong with it. You could require independent software testing. You could find out what the machine has said about the same subject matter before and see if the machine has made inconsistent statements. You could look at the source code if it's software and see if there's something wrong in the way that it is implementing a method. You can see if it fails to take into account key variables. You can look at validation studies. So there are different ways that we can think about showing errors that come from machines. But the reason that we can't just use the hearsay rule and say, oh, you can't bring in that software output, it's hearsay, is because the hearsay rule only applies to humans. So it wouldn't make sense to just keep out all machine evidence because we think we want to treat it like hearsay. So let me give you one example of a high-profile machine error in the DNA context. So there's new types of software that analyze DNA mixtures that are very hard for human analysts to figure out, basically impossible, because you have to go through hundreds of thousands of permutations to think about what the chances of seeing this evidence, assuming that the defendant is a contributor to this mixture versus assuming that the defendant is not a contributor. And so this software looks at the mixture, and then it reports something called a likelihood ratio, which is just a statistic. And so one of these software programs is called TrueAllele. Here's Mark Perlin, the person who invented TrueAllele. There's a competing program called StarMix from New Zealand. This is John Buckleton, who created StarMix. These are competitor companies, and they say very bad things about each other, and they sue each other and all of this. And so this is the sort of thing you would see in a real case. You know, a match between the beer bottle and the suspect is, you know, gazillions of times more probable than a coincidental match to an unrelated Black person. So to a jury, that sounds very damning, to say the least. So let me show you an example. There's a tragic case in New York a couple of years ago involving a 12-year-old boy who was strangled, and they didn't have a suspect. There was no physical evidence linking anyone to the crime. There was one person who was involved in a domestic dispute with the boy's mother, but he had what they saw as a credible alibi. Suspicion fell upon this man, Oral Hillary, who was a soccer coach and also had been an ex-boyfriend of the mother. He claimed he had nothing to do with it. There was no physical evidence linking him to the crime. But then police found a tiny bit of DNA, a DNA mixture underneath the boy's fingernail. Such a tiny little bit that it was a very complex mixture. By a DNA mixture, I mean a sample of DNA that you might find at a crime scene that has more than one person's DNA in it. So sometimes you can look at some blood or some other bodily fluid, some skin cells, and do a DNA analysis and realize it's only one person's DNA. There's only one person's genetic markers in there. And other times you can see that there's a lot of stuff in there. It's more like a soup. And you don't know how many people are in there sometimes, but you realize that it's a mixture. And so this is where the software can really help, because mixtures are very hard to interpret in terms of who might have contributed to this, how many people are in it, all of that. So the prosecution sent this mixture to TrueAllele and said, can you help us out? And TrueAllele said yes. And it returned a report saying, we conclude that Oral Hillary is not a contributor to the mixture. So the case went cold. A new prosecutor was appointed, was elected, and sent it to StarMix, the competing program. And StarMix said, yes, he is definitely a contributor. Had a very high likelihood ratio suggesting that he was definitely a contributor. So you have two highly sophisticated software programs, both of which were deemed decently reliable in validation studies, or at least developmental validation studies, but they both came to diametrically opposed results in a case involving the exact same DNA sample. Let me give you one more example, and then I think John and I were going to talk about the future. So far we've talked about software. You know, we're talking about a maximum of, say, 200,000 lines of code. It's very sophisticated, but you could look at the source code. But we are on the cusp of evidence that is truly deep neural networks, a level of machine learning. I mean, looking at the type of deep fakes that John was talking about that are well beyond what the programmer envisioned. And I'll give you one more fun example. One of these phrases was written by William Shakespeare, and the other phrase was written by a computer. So the first one is, "What's in the brain that ink may character, which hath not figured to thee my true spirit?" And the second one is, "King of hell, no quarrel have I left thee, no lovely maid who gleamed in fields or skies." Which one do you think is the computer? 1 or 2? 2 was written by a computer. The first is William Shakespeare. You know, the point of this example is, in order to truly confront machine evidence, it's not enough to just have the programmer on the witness stand to cross-examine. You've really got to get under the hood and understand what the computer is doing. And the more sophisticated AI gets, the more it will be almost impossible to truly understand how the machine has gotten to the expert opinion that it's giving. So it may be that in the United States, and I guess the world, we need to think of new ways to deal with this sort of evidence, deep neural networks and such. One thought is something called reversibility, that there are certain systems that can essentially be trained to be their own adversary, to try to reverse engineer their programs and to look for flaws and to scrutinize themselves. I think that will be important if we admit this type of evidence. We could just refuse to admit it, especially with respect to lie detection, on grounds that it violates the dignity and integrity of the process. But we're really on the cusp of something that eclipses the ability to truly to achieve some meaningful level of explainability when it comes to why they got the answer that they got.
I would say this: technology is not the friend we needed. Technology is turning to the foe we didn't know we had. I think it's going to continue to be a lot of evidence that's generated. I think we're going to continue to have problems with authenticity. And I think we're going to, all of us around the world, are going to have to continue to educate our brethren about the limitations of digital.
So on the Mayfield case and also on the mixed DNA, I think many people around the world, including legal experts, who are trying to find new ways to determine the truth, where the truth is critically important, say in the case of a terrorist bombing or harming of a child, the law enforcement's under tremendous pressure to solve those cases. And the lure of a technological solution is just very difficult to overcome. And so here you have a computer system, in the case of Mayfield, that purports to do something a human can't do, to go through thousands or tens of thousands of known fingerprints and come up with an answer that would be very difficult for a human to do. It turns out made a serious mistake. And then same thing with the DNA. While DNA is a great tool, this small sample of mixed DNA mixtures, we haven't cracked the code in a way that's truly, that science has a consensus opinion on. But the idea that you could have this machine or this algorithm give you the answer is so attractive, it's hard to resist. Is technology a friend or a foe? It's a neutral tool, but we can't invest it with too much problem-solving ability without fully understanding it. If I'm understanding both of your presentations, and proceed with caution. I think is the moral of the story, and I think this is particularly true in China, and there are other outside the United States, certainly in Asia. People live lives relying on technology even to a greater extent than we do, using their phones to make purchases, to engage in all communications. Technology is much more part of everyday life. So I think these cautionary tales are really important.
We just need a culture of openness and a desire to quantify uncertainty and embrace uncertainty. But I'm certainly happy that we, have these tools, and we just need to not be afraid to recognize their limitations.
I was given a presentation 2 years ago with a judge in California who does family court, and it was a presentation on phones and digital forensics. And he was saying how often that happens in family court. It's usually disputes over people who are trying to get divorced or fighting over kids or trying to get restraining orders, and they do not have attorneys. They're appearing pro se. And it is, he said, quite the experience, because he said every single case, someone tries to hand him a phone and say, look at this text string. It proves I'm telling the truth. And he said, judges really struggle with this. Should we accept it? And I was like, absolutely not. And he was like, why? And I grabbed my phone, and in about 10 minutes, I set up what looked like a text string where he was threatening my life. And it was me just sending messages to myself, changed the name of who sent it, and then manipulated the screen. And I was able to do that in minutes. And so that is one of those types of situations where you would need something else besides the phone to prove that didn't happen. I don't know about every case, because sometimes that's not the dispute. Sometimes the dispute isn't, I didn't send the message. Sometimes the dispute is, that's not what I meant. And if the dispute is, that's not what I meant, you don't need an expert. But if the dispute is, that's not, I didn't say that, then I think, yes, I think having the phone is not sufficient.
Trying to explain the American trial system to people who are not familiar with it, it helps to remember we have an adversarial system. And you notice even in the rules that John and Andrea talked about, there's a notice requirement, so that before the trial, each side is supposed to tell the other side what they plan to do. And the idea is to encourage the two sides to work out what they agree upon and what they dispute. So when you have a true dispute over the authenticity of something, well, then you may have to go into the more technical aspects of the rule. But if both sides agree, and as John said, they're not really fighting about what the documents say or what the emails say or the text messages say. They're fighting more about what they mean, or maybe the issue is something else. The parties can agree that these are authentic and that they're relevant and that they're admissible. So the system kind of relies on both parties who are adversaries to raise objections or to reach agreement if they can.
The cool thing is that anybody can do the hash analysis. Most of the hashing tools are free. So a lot of them you can just download and do a hash yourself. There are some that are pretty expensive that do a little bit more. But if you want to just know at a file level, the programs are free to generate the hash value. So I suggest playing with that and downloading one just so you can see what that's like.
Second question on whether there are limitations in terms of seriousness of case and the like with respect to a party's ability, the government's ability to seek a warrant, or a party's ability to seek information from a third party through a subpoena. Generally, no. There are a number of exceptions to the warrant requirements. The Fourth Amendment to the United States Constitution, which prohibits unreasonable searches and seizures, and requires probable cause for a warrant, has generally been interpreted to require a warrant. You know, there's a presumptive requirement of getting a warrant if you're going to go searching data that's in the possession of a private citizen without their consent. And of course, there are a million exceptions to the warrant requirement, but generally they have to do with, you know, consent or searching incident to arrest or exigent circumstances, emergencies and such. There's no murder exception to the warrant requirement, especially with respect to digital evidence. Our Supreme Court has actually been, I would say, unusually willing to require to enforce a robust warrant requirement when it comes to digital evidence like cell phones and cell site location information and GPS data, more so than other types of evidence. With respect to subpoenas, I think it's worth noting that generally you don't even have to go in front of a judge to begin with to get a subpoena, whether it's a misdemeanor, like a very minor crime, or murder. You really just need yourself to know that it's material to the case. It's relevant to the case. You need the information. And then it's up to the third party. If they think that you're asking for something that's not material, it's up to the third party to say, no, I'm not going to comply with the subpoena, and try to get the court to agree with them and agree not to enforce the subpoena. There are also some records, like an alleged victim's medical records, that are so sensitive that you do actually need to go and have a hearing in front of a judge to be able to get that information and make a much more serious showing. But otherwise, it's if you're the government, at least, it's pretty easy to subpoena information, and you don't need probable cause to do so.
If you're using the wiretap statute,
Yes.
which means a real-time interception of a communication, that's limited to very serious crimes, because that's such an invasion of privacy to intercept somebody's real-time communications. But the warrant requirement, as Andrea said, and subpoenas are not limited by the crime you're investigating.
Absolutely.
Although the list for wiretapping crimes is pretty long.
Where we've seen this come up first is with social media. So one of the things for authentication says it has to be a business record. So it's a complicated system of rules and laws. But when we get to authentication, one part says it has to be a business record. And what is a business record? I own a business. The traditional one is if I wrote on my letterhead a note to my secretary that said, go take $500 out of my trust account and give it to Andrea. That is a business record. It's a record that I generated for my business. And for some reason, people thought that that was not hearsay, meaning it was not an out-of-court statement. And so how that would work in practice is my secretary could come to court and she would say, yeah, that's John's handwriting. Yeah, he wrote that note to me. And yeah, that was in the normal course of business. And if that happened, the document comes in. So that is a standard way when we think about the business record. So if I go to Facebook and I post on Facebook that Andrea Roth is a mean, terrible human being, would Facebook be able to certify that that record is authentic? And there's actually, it's more complicated than you would think. I think the answer is clear. I think the answer is absolutely not. That is not, that is not a business record from Facebook. No one from Facebook created it. It was put on their platform. But there are two courts from the same circuit within the United States who have both looked at this question and and reach different conclusions. So I think 902.13, when we get there, also has a cross-reference to Federal Rule of Evidence 8036, which is the business record exception. And the question is going to be is this truly your business? Where I think that this really is going to come in is that someone is going to work at a big university or big company, and they're going to say, I'm the IP specialist for this company. I certify that I took data from our servers and I copied it and I provided it to Andrea. I think that's how we're going to see it play out in practice, but we still are sort of kind of figuring out where that's going. They really were, and that's a situation where I think the federal, that committee who wrote that rule, I think they were really trying to be forward-looking and thinking about how to address technological issues that they were failing on. I think they just could have done a better job.
So the example you gave, if the question is this an authentic post on Facebook that John posted to his account, then it would seem the business records exception, which we still call it business records, but it's a record of regularly conducted activity. But the content, what you said about Andrea, is still hearsay. And so unless some other exception applies, that would not come in. But, Facebook is essentially the custodian of records, as if Facebook was Bank of America. Bank of America doesn't really care, what you wrote on your check or your deposit slip, but they can say this, we found this in our records, and this is an authentic copy of our records.
Yeah.
Is digital different in that way? Is there something?
I think so, because first I want to answer the hearsay issue, and the example I was given, it should be more clear. It was a criminal defendant, so it was really, was it hearsay or not hearsay? And if the defendant wrote it, it was not hearsay. So that's okay. But as far as the business record, what is Facebook's business? And I mean that seriously. With the bank, I think you could say, yeah, if you have a bank, then you're banking. And so I think that makes the business record exception a little bit easier. But if you look at what is the true business of Facebook, is it selling advertisement? Is it bringing people together in a social community? What is it? And I think that's why we have courts, even in the same circuit, that come out differently, because there's a dispute about what Facebook is. So I don't think it's digital as much as it's growing technology like social media, and what do we do with that type of technology that's making a lot of people think differently about it.
In one of those cases, the court did not accept the evidence from Facebook. They said it didn't qualify as a business record and wasn't properly authenticated. So I guess there are examples where courts have not accepted the authentication. But as you can see, every one of these questions leads to 3 or 4 more questions. It's a complicated area, and a lot of this is still quite new.
The other thing is we're talking about ways to save time and money to get the post in without having someone to come testify. There are other ways that information could come into trial. Someone could testify that that was my account. Someone else could testify that they were chatting with me. Someone could testify that's consistent with the way I normally type messages. And so there are other ways. From an appellate standpoint, courts sort of decide, well, it got in or it didn't get in some other ways. They sometimes don't care as much, but you don't lose just because you don't win on the 902 issue.
And there are cases going both ways on emails too. And they've got this long list of, types of circumstantial evidence, and it either makes the cut or it doesn't. I don't know if there's a post-2017 email case, but there's definitely a bunch going both ways pre-2017.
There's 2 companies that, competing companies that often have the ability to get into locked iPhones. One of them is a company called Gray Shift that has a device called Gray Key, and the other company is called Celebrite, and they have something called Celebrite Advanced Services. It really is a cat and mouse game. From week to week, Apple is changing its security settings, and every time it does that, it changes the ability to get into the phones. And this type of forensics, they call it exploits, like you're trying to exploit a weakness. It changes so rapidly. I couldn't tell you the answer on any day-to-day basis. The other concern we had talking about validation is Gray Key, for instance, has a very strict rule that if they sell you one of your devices, you're not allowed to tell anybody about it, and you can't let anybody look at it. It's a very, very strict contract, and it's only available to law enforcement, which means we have an idea as a community in the defense of how it gets into the devices, but we don't know for sure. And the concern we have is we don't know if they are hurting any of the data on the phone when they're trying to get into it. So that's one problem. The second thing about it is that once when they use them from sort of like a practical standpoint, I've been told that sometimes it takes weeks or months for them to get into the device, so it's not always instantaneous. So even when they can get in there, it often takes a long time. So, but yes, we can often get into them, and it is a cat and mouse game.